Okay, thank you all very much for coming up to testify. I appreciate it. Okay, we'll now do the two con folks remaining who have signed in, Kyle Paskewitz and Lynn Hatfield-Wingender. And while they're speaking, Senator Patton requested, Carly, if you could distribute the testimony from Professor DeWolf. Thank you. Please proceed.
Good morning, Chairman Peterson and members of the committee. My name is Kyle Paskewitz. I'm a parent, a veteran, a child of divorce, and an advocate for parental rights. I'm the founder of Family Court Reform USA and the chairman of Parental Link, both national nonprofits dedicated to better protection for the fundamental rights of children and parents who face custody disputes in family court. I represent parents across the state of Washington, as well as nationally, and advocate for the promotion of equal and shared co-parenting. I've read this bill and thought about it considerably. If applied properly, this new law would provide some additional protections for at-risk children, which is something we wholeheartedly support. We agree that children should be allowed to develop and maintain bonds with their families, and when those parents and family members are fit and loving participants in the child's upbringing, it is in the children's best interest to preserve and protect those relationships. Our concern is that this law overlooks some of the other weaknesses in RCW 2609 that deny the rights of fit parents and would be invoked less often if these other issues were addressed first. For example, RCW 2609-187 makes it possible and quite common for one parent to deny residential time and decision-making to another fit parent based only on a preponderance of evidence. This scenario puts children at risk, not only by denying them the love and care of a fit parent, but also by permitting the lowest possible standard of evidence to be used by the courts to apply judgment using the vague and subjective legal doctrine known as the best interest of the child. It is often due to this denial of parental rights that a third-party relative of the non-custodial parent, a grandparent, a step-parent, or other relative, has to step in and help alleviate a situation that was created by a prior court order based on a lower evidentiary standard. Furthermore, this law may be used in unintended and harmful ways to further dissolve the rights of a fit and loving parent and their family. In another potential scenario, a custodial parent who's unjustly denied parental rights to another fit parent may convince their relative, a grandparent, a sibling, or a spouse, for example, to conspire to further erode the rights of the non-custodial parent and their family by petitioning the court for additional visitation time with other relatives. The situation could also be avoided if both parents' rights were equally upheld using the same clear and convincing standard when the original custody determination is made. It is my recommendation that the courts be required to apply the clear and convincing evidentiary standard consistently in all cases where the residential schedule of a child is being determined, upholding the presumption that fit parents act in the best interests of their children established in Troxel versus Granville. It is my position that without this standard applied consistently throughout RCW 2609, the fundamental rights of parents will continue to be denied without adequate cause and due process, resulting in more of the third-party visitation requests addressed with this bill. Thank you for your time and consideration.
Thank you very much. Please proceed.
Good morning, Senators. My name is Lynn Hatfield-Wingender, and I'm not here today, folks, to stand up against fit grandparents by any means. I loved mine. I loved my parents. Both of my parents are now gone. In 2009, just because my husband decided that he wanted out, he decided to try to make me emotional. So he got the custody of our children, and when I stood up against that, because there wasn't any good reason, just as he's described, then I just kept getting this terrible emotional sort of thing. Well, who's not going to cry when their children are taken? I've been able to see my kids 2.5 weeks of time in the past 8.5 years. I was the kind of parent who hosted all the daughters in the class to my kids' birthday parties. I taught kids to read in the classrooms. I taught Sunday school, and on and on. And I'm not unfit by any means, but I believe that the problem here, and why I wanted to come today, is that family court is our problem. Family court has too much authority, and it's not in the best interest of the family. If you stick a guardian ad litem on a case who is running a little cottage industry and is paid by the other party to say something about someone such as myself, frankly, I think that in a court system that is so swamped with so many divorces, I didn't even want mine, to put all this more additional hoops to have to jump through for all of these folks, I'm not sure that's putting money in a lot of attorneys' pockets and doing so upon people like myself who cannot afford attorneys to fight back. I think that this fellow was getting at the fact that alternate dispute resolution is what you should be looking at the beginning when someone comes into. In this case, my husband came in against the city of Olympia. They ruled in my favor, so he judge shopped to Thurston County, and he went to an unelected judge, Commissioner Thomas, who favored him against the city of Olympia's ruling. And there is fundamental injustice in family court. And I see my buzzer, so thank you for listening. I just feel that there's a big problem here that needs to be addressed, in addition, not necessarily against you folks. Thank you.
Okay. Thank you very much for your testimony. Do we have any questions for the panel? Okay. Thank you very much for coming forward today. We'll move to another panel of pro folks, Nick Bond, Marcy Johnson, and Julie Van Kirk.